Come up, Mr. Jones.
Mr. Nayland is in Cancun until Monday of next week, Judge, so he's not available this morning.
I understand.
So I'm kind of filling in. I have had a chance to look at this violation report regarding missed blows. I'm assuming that's our issue here today. Spoken with Mr. Jones about that. Pressed upon him the need for perfection here.
This is no tolerance. Absolutely no tolerance, because we've had one issue after the other. Testing positive for here, doing that over there. We've literally let you go over and over and over. And there's absolutely no excuse for the missed blows. How many missed blows do we have?
Your Honor, within that 7 or 8. But Judge, I would ask, if possible, as I'm not the lead on this case, and I know Dustin has had history with the court and Mr. Jones here on this case, if you would consider holding on the consideration of this matter until he returns on Tuesday of next week. So
I'm sorry, Ben, I can't. I have to know. You have to know that we mean business. I'm not here to toy with you and play games with you. Know what the expectation is in this court. You've been with me for as long as we've had. You're over there.
Because I have a cold, y'all. Cold weather. I apologize. So can I please speak on the breathalyzer?
No.
You
know what the expectation is. You have 19 missed tests. That's it. I'm sorry, Ben, I can't. You're here in his stead. You're a capable and outstanding lawyer. I have the utmost respect for you, but 19 missed tests are 19 missed tests. And I've been telling him since the absolute beginning, there's just no tolerance.
Please,
no.
But to his credit, Your Honor, we have no positive UAs. He's been here on weekly UAs, so there's no indication that he's using this to obfuscate. For
go to sleep early
test, and he is blowing outside the window, so we don't know what he's doing.
Oh my God, sir, I go to sleep at 8 o'clock every night, sir. It's just the 10 o'clock ones, and I get my 5 o'clock ones first thing in the morning, Your Honor.
Then you come here and you ask.
Oh, they just told me about this last week in pre-trial over there, and they said that I had a 45-day miss.
You have 19 missed blows, dude. Covering the camera.
Please, Honor. I will do anything. I'll even go on that drug, Anklemont. I'll do anything, Your Honor. I'm really trying here. I swear to God, I'll do anything you want me to do if you just please let me stay free. I swear to God, Your Honor, I'm really trying here. Please, Your Honor. It's just, I don't even drink.
From the 15th of November, you have been skipping tests. You have been to this court.
I go to sleep at 10 o'clock, and I still did the ones later on when I do wake up. And they told me this just last week, Your Honor. I swear on everything I love.
You know.
Please give me a chance, Your Honor.
Testing schedule is, and I've given you one
I started
pass after the other. He goes with you. No.
Oh, my God.
Your Honor, may we discuss setting a new bond for it?
Of course.
Oh, my gosh. Why? Please, I'm trying here. I'm trying to do everything.
Goes with you.
Oh, my gosh.
The bond is at 5,001 now because of the prior violations. I'll now set it at 10,002. I'm sorry, Ben, but he's tested positive literally over and over and over. He continues to test positive for marijuana. When I've told him to stop, he's tested positive for opiates. He's tested positive for this. Now he's skipping blows. He has obscured the camera as well?
It's not necessarily that he's obscured the camera, but it's too dark to view. It doesn't mean that there's.
It's the same thing. If we can't see you in the camera, then you're fooling. And I'm done with the fooling. That's it. I know that Dustin's gonna be pissed, but I mean, I've got it in black and white, and Dustin knows that it's no tolerance.
Consider 75 or 2, Judge, for bond.
Okay, Ben. Okay. Great. But he has to know that we mean business, man. If I let him go now, I'm enabling, and I'm not gonna do that. I can't.
In this section, the judge makes it clear that his patience has run out after giving the defendant many chances in the past. The judge focuses on the 19 missed tests as proof that the defendant continues violating court rules. Even though the defendant emotionally asks for another chance and blames missed tests on falling asleep early, the judge no longer trusts the excuses because of the history of failed drug tests, missed blows, and camera problems. By saying there will be no tolerance and that the court now means business, the judge shows that earlier leniency only led to more violations. Raising the bond from $5,000 to $10,000 sends a strong message that harsher consequences are now necessary.
But fine, because
Visit PC, Your Honor. I have some questions.
oh, you picked up a new case. I'm sorry, I'm just getting wind of this now. I didn't realize this. He just picked this up.
My client or the person?
Him picked up an interference 2 days ago.
That's what I'd like to revisit.
Yeah, of course. So you were on felony probation for a very serious case, evading arrest in a motor vehicle, which carries up to 10 years in prison. Now you've picked up a new case. Greg, I got to tell you that I don't know how much you know, but I have quite a bit of history with Mr. Zenon here. In fact, within the last 2.5 years, 1, 2, 3, 4, 5, 6, 7, 8, 9. Now he's on his 10th case. Specifically, an unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, a felony possession of marijuana, felony assault of a pregnant person. And I guess all that worked into a deal where he got on probation for an evading. And now we have.
Right, but all those cases were dismissed, correct, Your Honor? Okay.
Pursuant to the, I guess,
I understand.
that we literally had one after the other, like a run on a step ladder. One after the other. So let's do probable cause.
Thank you, Your Honor.
You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I just wanted to give you a heads up of how much history we have with Mr. Zenon, because it's a lot.
I appreciate that, Your Honor.
Sure.
But be that as it may,
I'm not going to hold, I've never will hold anything against him. So let's go.
On December 3rd of 2024, officers were dispatched to the HEB located at 4955 State Highway 6 regarding a disturbance in progress. Officers received 4 calls, all from witnesses who stated the defendant was arguing with and assaulting a female. While en route to the location, officers observed the couple at the intersection about 0.1 miles away from the HEB where the original call was
Observed what?
located. They saw the couple at the intersection.
Okay, they saw. Okay.
Yes, Judge. The defendant was uncooperative with officers. The defendant advised he and the complainant were involved in a verbal altercation and stated he threatened her, saying he would slap her. When officers advised the defendant that he was in custody for an outstanding warrant, he got upset and began to yell. Officers located a clear plastic bag containing 3.6 grams of marijuana. The defendant refused to comply with officers' commands to sit down and would not place his legs and feet inside the vehicle. The defendant pushed back against the officer's hand with his chest when he attempted to help him into the vehicle, pushed his legs straight and applied force toward officer's hand in an attempt to stop him from placing his legs inside the vehicle, and then used the bottom of his foot against the bottom of the door frame to further resist. The defendant refused to speak with officers and would not cooperate with the investigation. All witnesses on scene heard the defendant threaten to hit CW, and another witness stated she observed the defendant push the complainant in the chest and face with 2 open hands. He does have an active felony warrant from the Fort Bend County Sheriff's Office for aggravated assault with a deadly weapon.
But he has an open ag assault somewhere else too?
In Fort Bend County, Judge.
my understanding is it's
And
an
it was
older
open
case.
warrant at that time?
Yes, Judge.
May I respond to all this, Your Honor?
Sure. Please.
Where's the interference? Okay.
Well, they're putting him in a car and he's like going blank.
It's not interference with public duties. If they're sitting there saying they have a marijuana charge they could have done, is it a resisting? Maybe, but it's not an interference with the public duties. They said he didn't talk. He doesn't have to talk to them. And they're a 0.1 mile away from the location. For what?
Well, okay, I get that. But so we have what we have. We've got a disturbance at HEB. Cops go there.
Okay.
They start to talk to him, and I guess at that point says, "Hey, man, I'm going to slap her." So at that point, I mean, that's what we have,
Okay.
right, Mr. Zenon? There's always 2 sides to the story. I get it. This is just probable cause. It doesn't mean that you're guilty of this offense. It's just probable cause. That, in and of itself, is it enough to continue an investigation? And it is, because it's a potential terroristic threat, right? So they have enough to go forward to investigate. They start investigating, and then they find that you have a felony open warrant. And then they find there was something else was there another warrant that you said?
It's the aggravated assault, but Judge, I also would like to point out that
But they end up putting him in the car. And at that point, he basically just goes plank like this for them being unable to effectuate an arrest.
And Judge,
I don't think that's an interference.
I don't. I mean, I think the intent of the law within itself is that if you're interfering with their investigation for something else. He did not interfere with anything.
Hold on, let's read the code. Let's read it, because I mean, there's no better way. Let's read it.
Hold on.
I'll give you. Let's pull up the code.
Intake could have taken some other things, but
Well, certainly they could have taken a whole myriad of. I mean, you're lucky they didn't charge you with assault of a peace officer. There's a whole host of other charges that they could have put on. You know,
but they didn't hit. They took the one that I do not believe applies here.
Let's read the code.
Okay.
Let's see what the code says, because you know there's multiple ways that a charge can, that you can charge someone with facts, right? There's multiple ways that can. It's 3815.
In this section, the judge focuses heavily on the defendant's criminal history and sees the new arrest as part of an ongoing pattern rather than a single mistake. The defendant is already on felony probation and is now facing new allegations involving assault, marijuana possession, resisting officers, and an active felony warrant. Even though many earlier charges were dismissed, the judge still views the repeated arrests as signs of poor decision-making. At the same time, the judge reminds everyone that the hearing is only about probable cause, not guilt, and carefully considers the defense attorney's argument about whether the interference charge legally fits the facts. This shows the judge wants the legal process followed fairly despite concerns about the defendant's past.
You're right. It could have been like a resisting, but. Okay, you ready? A person commits an offense if the person with criminal negligence interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law. Two, a person who is employed to provide emergency medical services, a firefighter. Number three, for an animal under supervision. No. So I guess it's a person, it interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law.
That is the vaguest thing I've ever heard in my life. I mean, come on.
It is. I agree
Okay,
with
so the cop can claim anything is interfering with public duties.
Constitutionally, that is the vaguest thing I've ever heard of.
Judge, that's the statute. That's the penal code.
You'll find no argument with me, right? It is pretty vague.
Yeah.
It is.
He's got bigger issues. I mean, they should have taken the other charges, my whole point. I mean,
but he's disrupting the officer while he's trying to discharge a duty, right? The officer's trying to arrest him and put him in the car, and he's not letting him do it.
that's assuming they even had the right to do that. I mean, he's 0.1
It's an
miles
open
away.
felony warrant.
They didn't even know about the warrant. They didn't know about the warrant till after. So, I mean, that comes after all of this.
They're saying, go ahead. I didn't even give you a chance to talk.
No, you're okay,
Please.
Judge. They were investigating the assault, Judge, is what or the threat that he admitted to making. So it was an active investigation, and then when they were detaining him, he was resisting arrest, is what it seems like. And that's why it was charged with interference with public servant.
And there were also 4 911 calls that were made about this couple arguing. I mean, that's what they were investigating.
And the witnesses all described
They put him,
the
I guess, did they put him under arrest at the time when he said that he was making that threat?
And with being
I mean, did they have the authority to arrest at that time? Right?
So I think it was during their investigation, the defendant admitted to threatening, that he would slap Miss Clark.
And it's at that point they start to put him under
At
arrest?
that point, they ran him through the NCIC and they found that there was an active warrant, and then they informed him that he was in custody.
Okay, then that's a resisting from what they're using to say he's pushing back or pushing.
Remember,
That's a resist. That's not interference
could
with
be-
public duties.
But it could be that a set of facts can be multiple charges, right? So it could be resisting, but it could also theoretically be interfering with what he's trying to effectuate, which is an arrest. It's a duty that he's performing. He's performing the duty of an arrest.
But again, it's vague. It's the officer didn't put in the report. He's not saying in the dim summary, you are under arrest.
We don't.
Well, I mean, it's
Okay, well, I mean, but
we don't know. I mean,
Okay, I'm just saying.
if he says he's under arrest, but I mean, damn, it's all but clear.
I mean, this is.
We also don't have the offense report yet,
We don't
I
Judge.
don't care. I mean, but I think that there's enough, he places him in custody, right? He's going to arrest him, starts putting him in the car, and dude goes plank.
No, I know, but I don't have the.
I
I've
mean, I
shared the
think that-
videos with.
Remember,
Right, I haven't had a chance.
guys, this is a very low burden. This is probable cause. This is not beyond a reasonable doubt, Beyond a reasonable doubt is a different standard. This is just to see if there's enough to go forward. And according to this, you are disrupting, allegedly, you're impeding, and you're otherwise interfering with him trying to arrest you and putting you in the car. A person can interfere with duties in multiple ways. It's not just one way. Like you go over there and someone else tries to stop an arrest from happening. I don't know. I think that there's enough.
Whisper to me because I want to know what you're about to say.
And if you want time, you guys can go back and talk.
In this section, the judge carefully examines whether the interference charge legally applies while admitting that the law itself sounds very broad and vague. After reading the statute aloud, the judge says the wording could allow officers to label many actions as interference. However, he still believes there is enough evidence for probable cause because officers were investigating a disturbance and the defendant allegedly resisted and refused to cooperate. The judge repeatedly explains that this hearing is not about proving guilt beyond a reasonable doubt, only deciding whether the case should continue. Even though the defense argues the situation fits resisting arrest more than interference, the judge believes one incident can support multiple charges.
Okay, well, I got to say.
Required 3 times to search me.
Can I have a moment to look at the video? He's telling me a whole separate fact pattern.
But I need to give them time to be able to look at it too. I mean, it's noon. Why don't we do this? Why don't we roll it to Monday and we can, I'll find it now. We can reapproach Monday morning or tomorrow even. And if you find, if you find a completely set of different facts than to what they're saying on video, I'm all ears. I'm always all ears. I'm always willing to rehear probable cause at any time. I mean, it's not the be all end all. But for now, what they're telling me, if it in fact is the case, there's enough for probable cause to go forward. Is there enough beyond a reasonable doubt? I don't know. But be that as it may, okay, it looks like they didn't give him a PR bond on this.
Okay,
the bond right now is set at $2,500.
Okay.
Your bond upstairs is set at $5,000. Tell me about that Fort Bend case. Is it old? Is it new?
Let me check, Judge.
I think it's 2023.
Is it? I don't know. I mean, because looks like you got on probation in October of this year. When you're on probation, dude, on felony probation, you have a freaking halo over your head. You know, you got to be as good as you can. You're facing a lot of time in prison. Have you been to prison before?
Sir. No, sir.
It's not a fun place, you know, and I don't know what we need to do to get your attention, man. In life, if you're with a person that brings the worst out in you, then don't be with that person. There's a gajillion and one fish in the sea, but how can a person get you so wrapped around your finger to make you, you know, just go. It's like a cancer. When you have cancer, if you don't cut it out, it kills you. This is killing you.
I can contact Fort Bend Judge and get more information.
Well, it doesn't matter. It's neither here nor there. I'll do whatever you want to do. You want to set tomorrow, Monday? What in?
I'll watch it today and come back tomorrow if you want.
Yeah, I mean, if you want, surely. Do you have it?
We have the camera, the body camera.
I just shared.
Okay, so
They shared it. They just shared it with me.
let's roll it to tomorrow. You guys take a look at the video as well. Be prepared, and then we can reconvene tomorrow. For purposes of now, I'll find probable cause, and then we can regroup again tomorrow.
Okay, thank you.
Yeah. Okay. All right, Mrs. Zenon. See you tomorrow.
See you tomorrow.
How's it going?
Hi, Judge. Happy New Year.
New Year?
I'm here, Ms. Shaniqua Smith, Judge.
Okay.
I the court with an update on it. We have everything submitted for the DWI PTI program. However, Ms. Smith attempted to get the interlock device on her vehicle, but she has an electric vehicle, so she was told that it would not be able to get placed on her car. So Attorney Carter has been communicating with Beadle to try to figure out what we need to do then.
He's no longer here, so
Because we haven't heard back from him, so that's why.
yeah, he's not with the office anymore.
Okay. Okay.
Alex, do you have any idea what they do with electric vehicles?
So we do have information that she was approved for the DWI program, and then they emailed a procedure to follow. So presumably if she still follows the procedure outlined in the email sent from Beadle prior to his departure, then.
Well, the issue isn't necessarily the procedure, it's what do we do when we can't get the interlock device installed on the vehicle, which is part of the procedure based on her having an electric
Does she
car.
have another vehicle?
No, Judge. And I know she has to drive, so she can't do the portable because then she has to sign the affidavit, which would say she's sworn to not be able to drive.
So in that case, it would probably be best to reach out to Brenda Gomez or Bernadette Habe, who's in charge of right now the DWIs.
Hold on a second. Let's do that, and then your client has bond violations too. Do you know that?
No, Judge, that I did not know.
Shanika Smith, come up.
And it doesn't say that the concerned about my client.
Right.
I'm printing this out for you. Who is the other one? Gomez, and who is the other one? Alex?
Bernadette Habe. I can.
Oh, Bernadette, Miss Habe. She's the one in charge of everything, right?
Yeah, she's the one overseeing.
I mean, if you want to go talk to her, but she's got bond violations. Yeah, you guys go figure out, but you've got bond violations, man. I don't know what we're going to do now. Okay, please.
Thank you, I'll step aside, thank you.
Hey, what's up?
Just wanted to let you know I'm actually going to be the new DB prosecutor for here.
Great.
Yeah.
Great.
Good. How are you doing?
It's been a while, right?
It has been, yeah. Yeah.
Where you been?
I was just in court for, since I was interning, I went back to school, finished up, and then came here as a post bar. And then I've been in court for the entire time, and I just got moved into DB.
Okay,
Yeah.
so are you going to be just with us? It's 2 courts though, right?
It's 2 courts, so I'm in 5 and 7, so I'll be on the floor. So,
Thanks.
and I guess ERD whenever that happens, but somebody should be just covering me when I'm over there. But yeah, so I'll let you know.
Thanks.
Would you say about the PBR?
They're out talking.
I think that's something that's she's being told that the building side but it shouldn't be taken out of her account, but she will be possession. Yes, but still, we will experiment more. How long is she? Oh, yeah, she's not in charge of okay, I'm sorry.
Yeah, coach, please, man.
She didn't just get up so she prepared for pizza, so she just okay, then maybe she was happy with that. She's on the trial right now, right? I don't know, our supervisor's doing that. Whenever they're preparing to go on to PTI, they have to get surveys done. So I believe one of those supervisions, we don't state it. So to get approved for PTI, she had to get the additional petition, so just start getting that, and they might be required to pay. So that's probably what that situation.
Yeah, we call the complainant and see what
Commissioner Pro?
In this section, The judge shows a more balanced approach by delaying the final decision until the body camera footage can be reviewed. Although he already believes probable cause exists, he emphasizes that probable cause is a much lower standard than proving guilt and says he is willing to reconsider if the video shows different facts. The judge also gives the defendant personal advice, warning that being on felony probation leaves no room for bad decisions and comparing toxic relationships to cancer that must be removed. Later, the atmosphere becomes calmer as the judge handles a DWI case involving an electric vehicle and works through technical bond issues before welcoming a new prosecutor.
Would you like me to ask Ms. Smith to come up again? And I spoke to Wolf, and I didn't realize he had already had a conversation with her judge. And I will. I did speak to Wolven Carter, and he advised that he had spoken to Ms. Smith as well regarding the possibility of this being the result. He and I spoke to her again just a moment ago. We were out there on call, and at this time, Judge, Ms. Smith, that we were going to have her speak on her own behalf, Judge. So I think it's important for her to take ownership for what this report shows.
I don't care. I'm putting an ankle monitor on you now. And if you ever test positive for alcohol again, I'm going to put you in jail. That's it. No means no. Doesn't mean it's the holidays. Doesn't mean I have a birthday. A court order is a court order. And when you don't follow court orders, there's only one place that we have you go. There's no tolerance anymore. And I don't care what you come up here and say, whether it's mouthwash, a tequila lollipop, hair dye. I don't care. And I don't care who you're with. A second violation. Do you understand? Today you will get an ankle monitor, and I'm going to tell you now, it is extremely finicky. So best beware of anything that you put in your body. Okay, no more. That's it. Okay. As far as the other, I don't know. What I would suggest is, email if you can now, Brenda Gomez, and see how we handle it, because I don't know. All I know is that this case is nearly 200 days old, and now we have violations, and I'm ready to put this thing to bed. I'm not going to hold it anymore.
Yes,
So,
understood.
I'll give you guys to the end of the week, figure out what we need to do.
Okay.
But you're walking a very, very thin line. Do you understand? All right. So, Felicia, if we can amend it to put it on today, please. Yes, ma'am. Okay. Thank you.
Judge, can I get contact information for who you said I need to speak with? I'm going to make sure I have the email.
Yeah, so
I can just take a quick
the person looking at it is going to be Bernadette Havey. So yeah, you can just,
Okay, to make it easier though.
yeah. And then the other person, do you have Brenda Gomez's contact information?
Just make sure I have it.
I don't know if you got this email before, because it has it on there.
Okay, just so I can double check. I'd rather do this now than not have it later
Yeah,
if I
no
walk off.
Yeah.
Thank you.
No problem.
Thank you, Judge.
Take care.
Just don't be able to that's what Christopher Flores.
You are Christopher Flores. Mr. Flores, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and/or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir. Okay.
On December 29th, 2024, an officer initiated a traffic stop after observing a vehicle change lanes 2 separate times while failing to signal. The vehicle was speeding 58 miles per hour in a 30-mile-per-hour zone and passing another vehicle in a no passing zone. The officer made contact with the driver, the defendant, and made contact with the driver and the defendant, who is the rear driver's side passenger. Upon contact, the officer observed in plain view the magazine portion of an AR-15 sticking out from underneath the driver's side seat in the back passenger area. The driver denied having any weapons in the vehicle. The officer walked back to his patrol vehicle to write a traffic citation for the drive to the defendant in the back seat. The officer asked the driver again whether he had any firearms, and he stated he had 2 inside of a bag in the vehicle. The defendant stated that the guns were his and told the officer where the bag was. The officer located a bag containing 3 guns in the seat next to where the defendant was sitting. 1 AR-15 pistol lacking a serial number and 2 Glocks.
Mr. Flores, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to be in possession of any weapons. Do you understand? If you violate this condition, I'm going to revoke your bond. I'll put you in jail. No more PR bonds for you. How old are you, sir?
18, sir.
You're 18 years old. What do you do for a living?
I used to work. Right now,
Where do you go to school?
am I going to school, sir?
Where do you go to school?
MacArthur High School, sir.
Okay. I'm going to appoint your lawyer today, Mr. Flores, but no smoking weed, no possession of weapons. I'm telling you now, I'm going to be all over it. So if I find that you're violating any of these conditions, there's only one place you're going to go. You'll be doing school with me and back. Do you understand? All right. I need you to fill out an application for me. Or hold on a second. I've got one. I already got one. So what we'll do now is I'm going to have you sign a reset with Victoria. I'm going to have you take a seat in the jury box while we have you meet with a lawyer and meet with Fleischer for your bond conditions, and then we'll get you here shortly. Come on,
Right this way. Judge Random UAs,
please.
go ahead and sign for the reset.
And Judge, I'm Kenzie Watson. I'm the new
So is it Kenzie?
Mackenzie.
Mackenzie. All right. So Mackenzie, so on stuff where people are going to be monitored
Right.
for drugs, alcohol, we'll have Felicia do the bond conditions with pre-trial. For stuff where they're not going to be monitored, so for like like if we have someone else, just no weapons, I'm going to ask you to follow. Okay. So, you said your last name was what?
Watson.
Watson. Give me a second. Alex, are there any co-defendants in this case with Flores?
Let me check, Your Honor.
And then what time of day or night was this as well? Is he out in the middle of the night?
Flores, so it was looks like so it was at 10 p.m. So it was at night, Your Honor. And then there are no co-defendants on this case.
Any juvenile history?
No, Your Honor.
I think we're good then. All right.
All right, Judge, next is page 14. That's him, Sophia.
Good morning, Ms. Lepson. Ma'am, you were charged with theft. You're facing up to 6 months in jail and or $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On December 28th, 2024, the officer was dispatched to a target in regard to a theft in progress. The officer made contact with the complainant, the loss prevention officer, who stated the defendant entered the store, grabbed some Advil, went to the beauty department, put 2 lip glosses on top of the cart, made her way to a different aisle, picked out 5 air wicks, placed 4 of those air wicks in her purse, and grabbed 7 candles. The loss prevention officer further stated the defendant placed a bag over the candles to conceal them, went to grab eggs and hangers, and the complainant only paid for the eggs and hangers and the Advil at self-checkout. And the complainant observed the defendant pass points of sale without purchasing the other items concealed. The total was $188.83.
Got it. All right, ma'am, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to go to any target. If you violate this condition, I'm going to revoke your bond, put you in jail. No more PR bonds. Do you understand? What do you do for a living, ma'am? What kind of money do you make a month? Do you have any children? No? Do you have the ability to hire a lawyer, ma'am? I'll have you fill out an application. I'll take a look to see whether you qualify. I need to know everything about you. I mean, you have to meet the federal poverty guideline to be given a court-appointed lawyer. So I need to know everything about you, stocks, bonds, mutual funds, how much money you have in the bank, stuff of this nature. And then I'll take a look whether you qualify. All right? Please.
All right, Judge, next is page 20, Segundo. Come on up.
Thank you, Stephen. Hi. Are you with Mr. Segundo? And you filed an attorney of record?
His attorney of record is Nicholas Hale. It should be filed today, and I'm going to bring this up next with the associate.
Got it. Okay. Morning, Mr. Segundo. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, Judge. On December 30th, 2024, the officer was dispatched to a possible DWI at North South Houston Tollway in Harris County, Texas. The officer made contact with a witness who stated he observed the defendant's motor vehicle fail to drive in a single lane, driving on the improved shoulder and striking the right barrier wall. The officer observed the defendant's motor vehicle change from lanes 2 to 3 without a signal, signaled the lane change from 3 to 2, and then failed to signal a lane change when going back from 3 to 2. The traffic stop was then initiated and the defendant's motor vehicle pulled over at a high rate of speed, nearly striking the barrier wall. The officer made contact with the defendant, the driver of the vehicle, and the officer observed a strong odor of an alcoholic beverage, an unstable gait as the defendant walked, and red glassy eyes. The defendant stated he was driving home from being at a party. He had consumed 3 Bud Light beers and 2 vodka mixed drinks 2 hours prior to the traffic stop. The officer administered standard field sobriety tests, HGN 6 out of 6, walk and turn 4 out of 8, one leg stand 2 out of 4. The defendant read the DIC and refused to provide a sample. A blood search warrant was signed and executed.
Just Segundo, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to revoke your bond, put you in jail. No more PR bonds. Do you understand, sir? Any prior DWIs?
No, Your Honor. And license eligible.
Okay. As long as you have a valid Texas driver license and a liability insurance, you can continue to drive. Just be careful. It may become suspended. If it does, you can't drive. You've got a lawyer. Because you do, I'll waive your appearance, but you got to stay in touch with them. They'll tell you when you have to come back to court. If they tell me they can't get a hold of you, I will revoke the bond. So just stay in contact. Don't pick up any new cases and don't use. Questions? All right, man. Good luck. Thank you.
Right this way. I didn't see what Judge, that was the last one. Could you file the
Do you have any THAs?
Yes, Judge. Ready for this?
Yeah. Come on.
First one is page 1. Ayala, come on up. Go ahead and sign.
Do you need me?
Yes,
Okay. Let me just talk to him and then I'll bring it in. Come up, Mr. Ayala. Good morning, sir. Do you have a lawyer today? What are you doing about that?
Can't afford a lawyer.
Did you even look for a lawyer?
Yeah, I talked to somebody and I was trying to come up with the money.
How many lawyers did you talk to?
Like 3 of them.
That may not be enough. Sometimes you got to look 10, 15. You know, what do you do for a living?
Paper.
How much money do you make a month, would you say? How much?
500 a week.
I'll have you fill out an application. Let me take a look at how much money you make, and then I'll see whether you qualify. But I'm telling you now, you got to meet the federal poverty guideline, and I don't know if you do. So I need to know everything about you. Be honest, because it's an affidavit that you're filling out.
Yeah.
Okay. Do you mind giving an affidavit? It should be right there, please.
All right, Judge, next is page.
Oh, hold on, Vic. Let me just talk to him real quick. Yeah, of course. Come on. Good morning, sir.
Morning, Your Honor.
Hi.
Your Honor, I have Israel Barrena Vasquez.
Okay.
He's a DWI judge. I have applied for the PTI and submitted a mitigation package, Judge. He took the TRAS, Judge, and it's come back. And he's already paid the
restitution
DWI fee. He hadn't paid the restitution because he thought that's what that was. So if I can get him to pay that, and then he'll reconsider the PTI at that point, Judge.
So it's old. It's 191 days old. I mean, a week. Can you pay it within a week?
Yes, sir.
Okay, so we'll set you off a week, assuming he's got it paid. We'll come back and then, I mean, it's still on hold, right?
Still on hold. They're still not yet approved, but there's no sign that they've rejected it. So they're still looking at it.
No. The program in general. Like, weren't you guys going to have a meeting?
Right. They've enabled PTIs again. And as of now, currently our deputy chief is evaluating them. So they're currently evaluating for PTIs now. It's back going again. So.
Okay. Vic, did you hear that?
No.
PTIs are rolling. They're back.
Oh, what?
Top of page 2. So he still has to pay the restitution before. He's not paid the restitution yet, so I was going to give him a week to pay.
Okay.
Okay, so we'll give you a week.
Yes, sir.
Because
I'm
that-
going to offer if he doesn't get it done, so we'll get off of your doctor, Judge.
Sure, okay, I got you. So,
All right. So one of the friends is out to the house. Are you ready for the next CHA?
yes.
All right, it's gonna be page 12. Johnson, come on up.
Good morning, Ms. Johnson. Do you have a lawyer today? Tell me what you're doing about that. You need a lawyer, 100%. You may have had one for magistration, meaning when you first were arrested, but that doesn't carry with you to the end. What do you do for a living, man? What kind of money you make a month? Or let's do this. I'll have you fill out an application. I'll see whether you qualify. I need to know everything about you, how much money you have coming in, how much money you have going out, how many kids you have, and then I'll see whether you qualify. Okay? All right, do you mind? All right.
All right, Judge, next is page 13, Jones, come on up. Go ahead and send it.
Good morning, Mr. Jones. Do you have a lawyer today? Tell me what you're doing about that. What are you doing about that?
Trying to find one.
How old are you?
17.
You're 17.
Yes, sir.
Tell me what you're doing with yourself these days, Mr. Jones.
I'm trying to get a job.
Did you graduate from high school? Oh, this is no good. We're going to work on that. I'm going to give you a lawyer today, Mr. Jones. And I'm now sending you for a drug test. I want to know what, if anything, is in your system, and you're to come back. If you fail to take the test, if you fail to come back, I'm going to issue a warrant for your arrest. This is no good. You're not working. You're not going to school. You're 17. This is not a good way to start life, man. So I'm sending him for a test now, and then we'll have him come back, and then I'll give him a lawyer. All right, take a seat for me.
Judge, the state would request that we call Miss Johnson back up to amend bond conditions due to a call that we've done.
Sure. Come up, ma'am. So let's start. I don't remember anything about the case, so if you don't mind me reading what happened, please.
So, you want to?
So for this case, the officer was dispatched to a disturbance in Harris County, Texas, where the complainant and the witness stated the defendant had been texting and posting on Instagram about wanting to fight the complainant. The complainant and the defendant were inside an apartment when the fight began. The witness stated she observed the defendant to have a small, sharp blade in between her knuckles when hitting the complainant. The defendant punched the complainant in the face, causing lacerations and pain, and the defendant told officers that the complainant believed that the defendant was with the complainant's ex-boyfriend, which is what started the fight.
A fight and there's a blade and just...
We are going to get this case re-indicted most likely because she was also pregnant at the time.
Yes, Judge.
And,
Okay, what do you want?
I'm just requesting that for the time being, the bond conditions be amended to no contact with her mother, Crystal Williams, due to the complainant notifying me that she has been going near the mother's residence and also threatening her mother.
Who's the complaining witness in this case?
The complainant is Demiracle Williams, Judge.
Okay. And does she live with mom?
She does not live with mom. They live at different residences.
Because I really don't know if I can, you know what I mean?
I understand.
So have her call the cops
Okay.
if she's in fear, if she has anything of this nature, but I can't, on the complaining witness, okay, but on just an average other person, I don't think I can,
Understood.
But like I said, if she's ever in fear, if she has any issues, tell her to call, 911, call the cops, and then they can take it further from there.
Thank you, Judge.
Be careful. I'm going to protect my community at all costs, Ms. Johnson. Do you understand? All costs. Take a seat for me. What conditions do we have now? Just no contact with the complaining witness?
In this section, the judge handles several defendants while strongly emphasizing accountability, public safety, and strict compliance with court orders. With Miss Smith, the judge becomes very firm after another alcohol-related bond violation, warning that any future positive alcohol test will lead to jail time. He orders an ankle monitor and stresses that court rules apply regardless of holidays or excuses. The judge also warns a young weapon defendant that drugs and weapons could destroy his future, while expressing disappointment toward a 17-year-old defendant who is unemployed and not in school. Throughout the hearing, the judge repeatedly makes it clear that protecting the community is his priority and that continued violations will eventually lead to loss of freedom.